Gonzalez and Ms. Reeder are both in our virtual courtroom. Ms. Reeder, we've been having a little bit of technological difficulty, so if you'll go on mute while Mr. Gonzalez is presenting, and Mr. Gonzalez, if you'll do the same when Ms. Reeder is presenting, hopefully avoid some of the challenges we have had with sound. And you may proceed, Mr. Gonzalez.
3 minutes for rebuttal, Your Honor.
Very good.
Good afternoon. May it please the court. My name is Ralph Gonzalez. We represent the estate of John Frawley. As argued in the brief, a trial is a dynamic process and the right to call witnesses is sacrosanct. The appellees were able to present all of their experts, all the expert testimony they wanted to present. The appellant was not. And that brings me to the first assigned error, and that is the judgment should be reversed because the plaintiff, the appellant, was not provided the opportunity to call Dr. Stern as an expert in rebuttal.
Let's touch on one part of that argument real quick. You've taken the position, and you took it at the end of the trial, that Mr. Stern wasn't withdrawn. Did I misunderstand that?
That's correct. Dr. Stern was not withdrawn.
Let's go through this because we read the we all read the transcript. And starting at the December 2nd pretrial hearing, not opening any doors, under no circumstances should we be allowed to call Elliot Stern. We're withdrawing him as a witness. We're now in the position, we're withdrawing the expert that created this other expert. We're withdrawing. We're proposing that we withdraw this expert as if it never happened. I withdraw our expert. This is trial day 2. What they did after this man died is not accurately what the opinion is as an officer of the court. Later, same day, Judge, before you up on the bench, I withdrew Elliot Stern. Mr. Yared, I announced it several times. December 8th, on the record, Judge, I've officially withdrawn Elliot Stern. Later that day, we withdraw Elliot Stern. There's some reason he can't travel. He's suffering from cancer. Not only did we run out of time, I'm not calling him. December 9th, I'm not calling him. I'm not calling him. Same day, he's not available. He's been withdrawn as a witness. Same day, I don't know what you're talking about, withdrawn. So was he withdrawn?
Judge, let me be very clear. I want to break this down into 2 parts. I'll start with the second part, and that is he was never withdrawn for rebuttal purposes. No one ever said—
Mr. Gonzalez, let me ask a question then on that exact point. At the end of the plaintiff's case, the plaintiff rests. The court says, how would you like to proceed, Judge? The defense rests. Sorry, the plaintiff had rested, defense rests. All right, defense rests. Mr. Yared, no rebuttal, Your Honor. The court, no rebuttal? Mr. Yared, no, sir. The court, you know what that means. That's it for the evidence, right? Is that true? All the evidence is done? And Mr. Yared rested without trying to call Mr. Stern as a rebuttal witness. Tell me what I'm reading incorrectly about that.
Judge, at that point, that would have been the 3rd time that Mr. Yared—
No, that's not, but your argument was that Mr. Yared or your client was prevented from calling Dr. Stern as rebuttal. The only time rebuttal was otherwise mentioned by Mr. Yared was when he was cross-examining Mr. Fournier, and he said, I would like to— basically, he wanted to ask some questions for rebuttal, not impeachment, but rebuttal. The judge basically sustained an objection, can't do that. So now we get to the plaintiff and the plaintiff resting, the defense rested, defense then, or the case goes back to the plaintiff for rebuttal. I don't see anything where there was an effort to provide the deposition of Dr. Stern, or as a witness. We know that Mr. Yared represented he was ill and couldn't attend in person, but he didn't say anything about, I do have rebuttal, Judge. Are you going to preclude me from using Dr. Stern at this point as a rebuttal witness? There's nothing like that in the transcript that I could see.
There isn't, but by that time that had happened, there wasn't, which takes me to the point I was trying to make, and that is, at some point, you don't want to keep on going back to the trial judge trying to ask—
Before you make that point, which I think we understand, was there a proffer of what the rebuttal would have said? Had you been permitted to rebut?
And that's difficult to parse out from the record, Judge. The deposition transcript of Dr. Stern was put into the record. That was there. There was a certain section on page, I think it was 1291 of the trial.
It wasn't proffered or argued that way at trial.
I'm sorry?
Your argument now is piecemealing it out, but that was not made at trial. That, Judge, the rebuttal would appear on pages 10 through 15. That's what we want to profit.
No, that wasn't in the record.
Okay.
When you look at the trial record,
well, I mean, you're not saying it's an off-the-record conversation, are you?
Yes, Your Honor, and that's
okay. We don't know what that is, and it's not in the record, so it's not relevant to the appeal.
Judge, on that page that I was referring to, which I believe was trial transcript 1291, and I can get the correct transcript, but Mr. Yared was trying to articulate what the basis was for what was being asked to be done. And the judge said very clearly, it's in the record. You've done that. You don't need to do anything else. And that terminated that discussion. But I don't know that we need to.
That was not for rebuttal, Mr. Gonzalez. That was earlier in the trial, right?
Well, that's correct. Yes, it is. That was the second time.
Okay, but again, I mean, it seems to me what the judge is saying at the close of the case is, and I wasn't there, so I don't know what the inflection in the judge's voice was, but he says no rebuttal, no rebuttal. Maybe he said no rebuttal, but how I said it, he then says, you know what that means? No more evidence. I mean, I'm not sure if the judge was inviting Mr. Yared to now revisit or not, but Mr. Yared didn't. And I don't know how we can get around that to say the judge was wrong to not allow rebuttal because the judge invited rebuttal.
Judge, if I could go back to the first of the 2 points I was trying to make. And the first point I was trying to make was with regard to all the statements that were made prior to the end of the December 2nd hearing, because it was said several times, Mr. Yared said several times that he was withdrawing the witness. And then Judge Muscarella summarized all that. And what she said was, and this was on page 8387 of the supplemental record. It was cited in our reply brief. And the court says, I think it makes a good argument if the book comes in with those parameters, he's entitled to dispute that, meaning with Mr. Fournier, the engineering expert. And then Judge Muscarella says, however, if you want Mr. Stern to stay in with his theory, that's fine too. So despite all the earlier statements that had been made, where Mr. Yared was saying that we're withdrawing Dr. Stern, that was the actual ruling of the court.
That is really helpful. So now if you'll point me to on the plaintiff's case where Dr. Stern's deposition was offered to be read and the judge refused.
That was the first time, and I believe that was on page 1123 of the trial transcript, where Mr. Yared asked to read the excerpts of Dr. Stern. That was on page 1123. And then the judge.
Wait. But that's when Dr. Fournier was being called out of order, correct?
That's correct. Yes, it was.
And it was presented in terms of, I want to ask Dr. Fournier about some of the things relating to Stern's deposition. And the judge said, well, that's not rebuttal, basically. And so I'm not certain how that, in fact, I'll say it differently. When Mr. Fournier finished and moved off the stand, and we're now back in the plaintiff's case, did Mr. Yared say, okay, Judge, now I want to read Dr. Stern's deposition. We let the witness go out of turn. We're back in our place. Now we know they're making a big issue about the temperature more than I ever wanted to. I'm entitled to now bring his deposition in. Did he do that?
Judge, Mr. Fournier was directed to testify at page 1082. And I don't know how long that testimony was when Mr. Yared was asking to read those trial transcripts, but that was at 1123, which was some 50-odd pages later. That may have been in the middle of Mr. Fournier's testimony when that happened. The point that I was trying to get across was that it seemed as if there were two, if not three times when Mr. Yared was trying to present Dr. Stern, whether it be in terms of I want to read excerpts or I want to call this witness, or I want to cross-examine him on Dr. Stern's testimony. And the judge basically said, no, you've withdrawn him. I think that was the position that the court was taking.
Did Mr. Yared lay a foundation to impeach Mr. Fournier with the deposition of Dr. Stern?
I'm not sure that I understand the question, Judge, because
Did he say, did you review Dr. Stern's deposition in preparing your opinions? Did he say, I'd like to ask you or go through the deposition to see what you read and whether you agree with it or not? Did he do that?
No, sir, that's not in it. That's not
exactly what he said is, I want to ask some questions in rebuttal of Mr. Fournier while he's on the stand, right?
Yes, Your Honor.
And that's not proper rebuttal, is it?
Judge, I think that no, it's not proper rebuttal. Okay. It is not proper rebuttal.
So now we move to Mr. Fournier leaves the stand. We're clearly back in the plaintiff's case. It seems to me that's a point at which the plaintiff says, Judge, we know we said we withdrew this witness, but here is a really important reason why we need to call him and present his deposition. Was that said?
Judge, that was not said on the record.
So all right, that's your answer. So now we go to the end of the case, defense rests. And I know this is repetitive and I apologize for it, but I'm not certain how we could reverse on this issue when it doesn't appear the plaintiff, in fact, offered Dr. Stern's deposition. In fact, if the plaintiff had offered to read certain experts as certain portions as rebuttal, presumably the other side would have said best evidence or completeness, let's get the whole deposition. And nobody really discussed any of that in front of the trial court, did they?
No, Judge, but that's where I tried to go to page 1291, because 1291 was after Mr. Fournier had finished testifying. He was done testifying at that point. And Mr. Yared asked if he could call Dr. Stern. It wasn't about reading excerpts at that point, but on a trial transcript at 1291, he was asking, can we call him? And that's where the court said, it's in the record, your request. Basically telling him that he couldn't do that. That was his effort then and there to call him in his case in chief in order to present him as a witness that was, in fact, rebutting the testimony of Mr. Fournier, but that was his attempt to call the witness at that point.
Do me a favor, tell me what line you're looking at, because I'm looking at that page right now.
I believe if you look at line 10, Mr. Yared says, I want you to be aware that the record, when we asked to call the witness. And
okay, let's stop there for a moment. That seems to be a reference to the cross-examination of Fournier. Because I think that's the only time up to this point that Mr. Yared wanted to use his deposition.
Judge, again, we're talking about the off-record conversation that took place.
No, we're not going to talk about the off-record conversation. It's either in the record or it's not. So right here, I'm trying to figure out where he says, Judge, I want to call Dr. Stern. Are you precluding me from doing so?
Those words aren't said. And again, I don't mean to be disrespectful, Your Honor. But
I know you don't. You're making the best argument you can with what's in the record. And I don't want to belabor the point anymore. I don't want to take all your time on this one issue. You have other issues. You obviously hear the concern that I have about this. So you can either continue on with it or move to something else.
And I'll take 3 seconds just to say, if you look at lines 15, 16, and 17, the court is saying it's in the record. It's in the record. And then Mr. Yared is saying, now it's in the record. So I think that's all I was trying to finish up on that. If I can.
Okay, well, I have to ask you that, is that adequate to introduce it into evidence as a substantive presentation for a jury.
To call Mr. Stern is the point I was trying to get across, that he was wanting to call Mr. Stern at that point.
When the judge says it's in the record, though, Mr. Yared doesn't say, Judge, I don't care that it's in the record. I want to call him as a witness. I want to read this to the jury.
The discussion that was happening was whether we had asked to call Mr. Stern, that we had wanted to call Mr. Stern live, as opposed to the earlier, 100 pages earlier, when the transcripts were being talked about being read. Now there's a discussion about, let's do this live. Let's have Dr. Stern there.
Okay, I honestly, I don't see those words there, but we'll make sure.
It would have been complicated anyway, because Mr. Yared had already represented that Stern wasn't available because he was undergoing cancer treatment and couldn't travel.
Dr. Stern was going to make himself available to be there. That's again, this is the off-record discussion that took place, which I don't want to go there. Judge Silberman is asked me not to do that. If I can move on to the second assigned error, which is it was error to allow Dr. Yaffe to offer speculative testimony, Judge, and Your Honor, in this case, we filed a motion in limine in September, months before the trial took place.
There was chase with your opponent's argument that this is waived because you never asked for a Daubert hearing.
We had a Daubert hearing. The Daubert hearing was.
Then why does the order say the only way we're going to revisit this is at a Daubert hearing?
Oh, well, okay, and that's where we tried to do the voir dire of the witness in order to establish the absence or the lack of predicate that was speculative testimony. That's what the purpose of voir dire was, to demonstrate to the court, and in other words, to have a Daubert hearing right then and there.
Here's the thing: we confronted with this paper record, and what the order says is motion in limine denied. Call it up for a Daubert hearing if you want to go further with this. That never happened. I've searched the transcript for the mention of Daubert. It does not appear anywhere in the 1,416 pages of the transcript. There's certainly no paper record of a filing asking, and I get it. I understand the situation that you're in 6 days before trial with this ruling on this witness. But at that point, to preserve this, either you had to ask the trial judge for a Daubert hearing before the trial, or to conduct a Daubert review during the trial and have him turn you down either to do it at all or on the merits. And that didn't happen. So how do we review this now?
Judge, Daubert was not mentioned during the discussion when Mr. Yared was objecting to this witness and requesting the opportunity to do voir dire. But effectively, he was making a Daubert challenge because Mr. Yared was talking about there's a battery of neurological testing that needed to be done to render stroke opinions. This was all on pages 807 and 808.
Well, wait, I mean, I'm looking at the appellee's response to the third motion in limine, and they argue that the motion in limine looks, quacks, smells like a Daubert motion. And then they say it should be denied as legally insufficient. But they say if the court finds that the plaintiff has raised a valid Daubert challenge, this must be set for an evidentiary hearing. When the court enters an order denying the motion in limine, which is what the appellee wanted, and saying, if you want to go further with this, we got to have an evidentiary hearing under Daubert. And again, I get it. You're 6 days away from trial. The likelihood of getting an evidentiary hearing in front of the assigned judge before your senior judge comes in to try the case, and you're on a tight timeline. But in hindsight, and sometimes hindsight's important with preservation, even if you thought your goose was cooked, you needed to get a reference in this record that the trial judge was confronted with a Daubert argument and turned it down one way or another. And I just don't see it. So tell me again how this error is preserved.
You won't find Daubert in the record. It's in the trial transcript, not with regard to Dr. Yaffe or any place else that I saw. you will find the idea or the basis for a Daubert challenge being argued in a trial transcript on pages 807 and 808. And that is what we have as far as being able to raise that issue. You know, we're talking about, I guess, using Daubert as a you know, for nomenclature purposes, that somehow we have to use that word Daubert in order to effectuate what it is. Had we just said, okay, Judge, we're not going to have a Daubert hearing.
But we know that the procedure on a Daubert challenge is an evidentiary hearing, and I think you're acknowledging that when you're talking about a voir dire. I'm looking at the transcript, and I don't see it where you referred us to at 808 and thereabouts. I don't see any attempt to invoke the court, you know, to invite the court to conduct a sidebar and do an evidentiary review or anything that even remotely smells like a Daubert review at this point. So, and I don't mean to beat a dead horse, it's just without the error being preserved, we've got problems. If the trial judge had denied your Daubert motion or denied your request to have an evidence, you know, to stop and review the evidence, as you were calling it, the voir dire, then we could look behind it. But what we have here is a directive, and I don't think it came to a surprise. It came as a surprise. You and Mr. Yared were both there. You're both highly competent trial lawyers, that you need to have a Daubert evidentiary hearing.
Judge, what I hear you saying, and maybe I'm misunderstanding, but what I hear you saying is that when Mr. Yared on page 807 of the trial transcript on line 8 says, at this point in time, I would like to voir dire the witness. Now he's gonna be under oath. We're gonna be asking him questions under oath. It's gonna be an evidentiary.
And what does he say? What does he? That was on what page? 805.
807, Your Honor. At
okay.
This point in time,
let's go. Mr. Gonzalez, let's do a couple of things. First, I've given you an extra 5 minutes. You've already finished your rebuttal time, but I'm going to let you preserve that. I'll give the other side an extra 5 minutes as well. So take 1 more minute to answer Judge LaBritte's question. I'm not going to ask another question at this point. And then you'll have, actually you reserved 3 minutes, but I'll give you 4 minutes for rebuttal because we've asked you a lot of questions. So you now have a total of 5 minutes left for your argument, 4 of which you can reserve for rebuttal and 3 you can reserve for rebuttal. But if you take the 5 minutes, you'll be done.
Thank you, Your Honor. Judge LaBritte's question, I'm sorry, I don't remember what the question.
And I appreciate that you've been heavily questioned today, but I am looking at the part of the transcript that I think you referred me to. And fundamentally, my question is, is there a way we can review this if it wasn't preserved by virtue of an attempt to have this trial court conduct a Daubert review? And what I'm seeing is Mr. Yared says, you know, I'll give you a couple of, he says, can't you wait till you cross-examine? No, and not until he gives testimony. I'd like to blah, blah, blah. I can show you where I'm going if I have 3 minutes. And then he starts talking about another witness, but he doesn't talk about what evidentiary considerations would be relevant here. So that's my question. I don't think that the testimony, the discussion, the colloquy at the pages that you referred us to gets you there, because it's just not sufficiently clear that I need a ruling on the Daubert challenge to this witness.
And on page 808 is where he lays the predicate for why the Daubert challenge would be made. The different things that would be required or expected to make this kind of testimony. Even if a Daubert challenge had not been made, Your Honor, even if, and that's why we cited the St. Joe's versus Cox case, because when you take the testimony of Dr. Yaffe, it is patently clear that he is basing that testimony on his watching the video. That's the basis for his testimony. this court rejected the testimony of Dr. Futrell, as argued in the reply brief, who was a neurologist, a stroke expert, and had a number of other credentials. The Florida Supreme Court came back in reverse and said that because she's a stroke expert, because she has all these credentials, because she looked at the CT films, could actually see the stroke herself, that it was appropriate to allow her to testify to these things. None of those objective indicators are here with regard to Dr. Yaffe. So our argument is twofold. It's number one, there should have been a Daubert hearing during voir dire. That's where that should have occurred. We should have been allowed to do that. And then two, forgetting Daubert, all right, we can look at the record and we can conclude that this testimony is inherently speculative. And if you watch the video, there are multiple times in that video, because the whole basis for Dr. Yaffe's opinion was he was having a left-sided stroke. But if
Mr. Gonzalez, just to let you know, you've got 3 minutes left total. If you want to reserve any time for rebuttal, this may be when you want to stop.
And I'll finish with the 15 seconds. At 5:41, at 7:15, at 7:21, those are all different times in the video where he's plainly using his left arm. There's no basis for that. I'll reserve the rest of my time. Thank you.
Ms. Ryder, you have 27 minutes if you need to use that.
Thank you, Your Honor. May it please the court. I'm Alyssa Ryder from Wicker Smith. I represent the Appalese. Oak Hill Management.
Mr. Gonzalez, if you would put your microphone on mute, please. Sorry, Ms. Ryder, go ahead.
Okay. I represent Appalese, Oak Hill Management, Florida, and WRD Providence, Palm Harbor. I would like to start my argument by clarifying something regarding this Daubert issue. And Judge LaBrite mentioned that the Daubert order was shortly before trial. And while technically that's true, I did want to just remind the court that actually the original ruling about Dr. Yaffe was made back in November, because the arbitrator had made a ruling that this was not, that the motion in limine was denied, and that if the plaintiff wanted to pursue it as a Daubert issue, they would have to set it for a hearing. So that ruling was made in November. Shortly before trial, the parties both agreed that they would have the trial court adopt that arbitration order on the various motions in limine as a controlling order on the motions in limine for purposes of trial. But what's important is the plaintiff knew for months before trial that if he wanted to pursue this issue, he was going to have to set it for a Daubert hearing, and he never did. So it's just...
so let me ask you the question based on what I understand to be his response, and hopefully you've got access to the transcript pages that he referred us to for the predicate for the Daubert. What do you have to say about the colloquy there, and whether it suffices for purposes of laying the predicate and being turned down on it?
I do not think that it satisfied it. For one thing, the parties knew when each other's witnesses were going to be coming to trial. And I have to tell the court, I do have many excerpts from the trial printed in front of me. I don't have every single page of the transcript, but my recollection is that there is no time before Dr. Yaffe got on the stand where the plaintiff asked the judge to conduct any sort of hearing outside the jury's presence for purposes of doing a Daubert contest. Never advised the court that this was going to be an issue. Then when Dr. Yaffe gets on the stand, he asks to voir dire the witness. Well, that happens routinely at trials where parties want to voir dire a witness about their credentials, but that doesn't mean that it's a Daubert hearing.
Can I ask you one question? Was Dr. Yaffe tended as a particular type of expert, or just the questions were asked and there was no motion saying, Judge, what kind of an expert do we have here?
Well, he testified that he was an internist, and
it was a medical expert of some sort, correct?
Yes, he was an internal medicine doctor. He was the defense expert.
Here's where I'm going. this case is about causation of death, right? Hypothermia or a medical condition. He said he may have suffered a stroke, but then the court, I assume, instructed the jury at the end, you've heard expert testimony, you can consider the testimony. If you find that person expert in the field, he or she testifies. Did that happen in this case?
Yes, and the jury was told you can give experts testimony the weight you think it deserves based on their credibility, etc.
That's typical.
Yes, and so during the sidebar, when plaintiff's counsel brought up the issue of doing a board
is this on the is that on the record?
Is what
is the sidebar you're about to refer to on the record?
Yes, it is.
You can refer to it then.
Yes, I'm referring to the same page range that Mr. Gonzalez was referring to. This is from pages 805 to 812 of the transcript. If you look at it, he does say he wants to voir dire the witness on his qualifications if he's talking about cerebellar ataxia. Okay, I don't think that's the same thing as preserving your request for a Daubert challenge.
Well, you didn't get a ruling. You didn't get a ruling on Daubert regardless, right?
He actually withdrew the request.
Yeah. I was going to say, read the next few lines.
Right. He does say on page 806 that he withdraws the request, but in candor, then on the next page, 807, he brings up again that he wants to voir dire the witness. Another example of which seems like a theme in this case of the plaintiff going back and forth on things. But so the court asks plaintiff's counsel on page 807, line 12, can't you wait until you cross-examine? And counsel says, not until he gives testimony that this says voir the witness for the court to determine it should be given. I can show where I'm going if I have 3 minutes. So this is not a request for the court to stop the proceedings and do a full-blown Daubert hearing. He just wants to ask a couple of questions.
Let me make sure I understand your argument, Ms. Ryder, because I think we can reduce it down. You're saying that here he was focused on one aspect of the stroke evaluation, ataxia, I can't pronounce all those words, as opposed to whether Yaffe's testimony was purely speculative based on, because he didn't have an opportunity to an autopsy and various other forensic information, that he was basing his testimony on the video and that was speculative. But here, and again, I'm just trying to make sure I understand what you're saying. Here, he's not focused on it's speculative because it's based on the video. He's focused on he may not be qualified to opine on cerebral ataxia or whatever that word is. Do I have it right?
Right. He makes that one reference, and I would say that that is insufficient to constitute a request for a Daubert hearing. Yeah, and you have to look at the totality of this, right? The trial starts, there's no indication that he ever alerts the court that he still has a pending Daubert motion that has to be ruled on. He had months before trial to get it set. He doesn't. During the trial, there's no indication where he asked the court, can you come in early? Could we stay during lunch? Could we have this Daubert hearing? And the court has obviously read this transcript, and you've seen that this trial judge was extraordinarily accommodating and patient with all these requests. And that never happens. And then the judge says, I will deny your request for voir dire at this point and leave it all for cross-exam. That's on bottom of page 812 to 813. But if you look at the cross-examination, there's no cross-examination that you could say constitutes the type of questions you would ask at a Daubert hearing. So the whole concept of challenging him under Daubert was abandoned and not preserved. And that's why this argument regarding Dr. Yaffe should be rejected.
Let me ask a question on this point, because there is a point in the pages you were just looking at where Mr. Yared says, I want to voir dire him, which we know is different than a Daubert hearing. But wouldn't he have been entitled to voir dire him to not challenge on a lack of a scientific basis, but to voir dire him in terms of, is this within his area of expertise?
Perhaps, but he hasn't raised that as an issue on appeal. So, and not to be cute in answering Your Honor's question, but I think it's a moot point in that it's waived. That's not one of his issues on appeal. I also want to just briefly touch on this issue about whether Dr. Stern was or was not withdrawn. And I think during the opening argument, the court has made it clear that it's well aware of all the times where plaintiff's counsel took the position that Dr. Stern was withdrawn. I did want to point out as well that throughout the initial brief, the appellant repeatedly states, if you look at page 2, page 22, page 23, page 24 of the amended initial brief, the appellant repeatedly takes the position that Dr. Stern was withdrawn. And as well as, and some of these pages, I think the court may not have mentioned, transcript 87 to 89, transcript 986, and record page 8374, that he repeatedly takes the position that he was withdrawn. And what's important about that is that the defense prepared their expert, Mr. Fournier, based on that understanding that Stern was not going to testify at trial. And as Mr. Reed, who was trial counsel for the defendants, as he explained very carefully to the court when this issue came up, Mr. Fournier had two areas of testimony that he was going to provide. One area of his testimony had to do with completely disputing all of Dr. Stern's methodologies and theories and theorems. He had all sorts of mathematical calculations and reliance on various things that the defendants contended were just completely baseless.
Well, you're putting the cart before the horse. Let me just interrupt you with a question. Had the judge abused her discretion in this case? The judge had discretion to allow this testimony and chose not to allow the testimony.
Correct.
Had the judge allowed the testimony, then you'd be arguing these things. We were prejudiced. Is that true or false? You don't need to argue those things, why the judge did what the judge did, because we're not there yet. You're making an argument that doesn't really apply until after you get a ruling against you, and you had a ruling favorable, so you don't need to worry about the abuse of discretion standard being violated. You can say whatever you want. I'm just thinking out loud and asking you a question to save you some strokes. Okay. No pun intended.
I think the reason it's important is in terms of putting in context why the rulings occurred the way they did.
I got you. Okay.
But I agree. I hear what you're saying. I don't disagree with it. I think that what's important about why it would be prejudicial to us is to understand why, after the plaintiff repeatedly stated that they were withdrawing Dr. Stern, why at the very last minute the court wasn't going to allow Dr. Stern to either testify or to have parts of his deposition.
The only reason I asked that, the judge didn't explain all this, correct? What you're saying now is you're theorizing, but the judge didn't physically explain all that, or did she?
Well, it was a male judge at
I thought it was Muscarella, sorry.
Right. Judge Muscarella was the pretrial judge.
Okay. All right. My mistake.
That's no problem. It was Judge Ramsberger who actually conducted the trial. He sat in for her. Let me see if I have those pages, because I think the court may not have gone into the detail I'm going into, but it did basically explain the reason for it. But the point I wanted to make before I forget, on page transcript 1291, it was brought up that that it was raised again about that the plaintiff wanted to call Dr. Stern. I don't actually have that page of the transcript in front of me, but I have extensive notes about it. And when I read page 1291, I disagree with the plaintiff's representation of what was being discussed there. What was actually being discussed, if you look at pages 1290, 1291, this was after the fact. Plaintiff's counsel comes into court and tells the judge, oh, by the way, there was a moment days ago where Mr. Reed told you that we had not formally withdrawn Dr. Stern, and he's wrong because we had withdrawn him because he had misspoken at that point. And the judge says, well, okay, so, and plaintiff's counsel says, well, I'm just bringing this to your attention. And the judge asks him, well, you know, what do you want me to do about that? And he says, well, there's nothing. The plaintiff's counsel says, well, there's nothing to do about it at this point. And the judge says, fine, it's on the record. That's what that on the record reference had to do with, was plaintiff's counsel was just basically trying to point out that Mr. Reed had made a misstatement at one point in the trial. It was just a non-starter. And that's why the judge said to him, well, okay, whatever. Basically, it's on the record. What do you want me to do about it? And the plaintiff's counsel says nothing. So it's just another example of where the appellant is taking parts of the transcript and construing it in a way that is just not accurate. And so just pointing that out. I did want to mention too that even if this issue about using Dr. Stern as just a rebuttal witness, even if that had been preserved, which we don't think it has for various reasons that the court's already discussed during the first argument, but even if it had been preserved, the fact that he had been withdrawn at that point, and so therefore was essentially an undisclosed witness, the trial court still had discretion to deny the request to use him as basically surprise rebuttal testimony. And there's no abuse of discretion on this record. And this goes back to what you were asking about, Judge Belanti, about why does prejudice matter? And it matters in terms of that even if they had properly preserved this issue, which they have not, then because it would have been prejudicial to the defendants, because it would have been disruptive to the trial at that point, because there was some indication of intentional conduct by the plaintiff, then under the Binger criteria, the judge was well within its discretion to deny the request. You know, this whole issue about withdrawing Dr. Stern, if you look at the transcript and you look at the record, you see this all started actually long before the trial, that the plaintiff filed a motion to withdraw Stern if we would withdraw our expert, which we never agreed to do. And so there was this continuing gamemanship where the plaintiff was trying to manipulate this trial to get what it wanted, which was really that our expert, Mr. Fournier, not testify. That was their end game. And they've tried to convince this court that the parties agreed that if Dr. Stern was withdrawn, we wouldn't present Mr. Fournier. It hasn't really been discussed, but I'm sure the court fully understands the position that we've taken, that we explained in our brief, that we never agreed to that. And in fact, if you look at the reply brief, the appellant quotes Mr. Reed's statement during that pretrial hearing where he says, Judge, it's going to be a game day decision. So he was always transparent about the fact that he was not going to withdraw Mr. Fournier, no matter what the plaintiff did regarding their expert, and that as long as the plaintiff intended to pursue this unpled legal theory, which the defendant kept asking the court to please strike, but the court never did, that as long as the plaintiff pursued this unpled legal theory of the temperature of the spa supposedly being too hot, that we had to have the ability to call Mr. Fournier to refute that claim.
Ms. Reeder, I've lost your voice. Would you go to mute for a moment and wait about 3 seconds and then come back? Let's see if that fixes it.
Okay, can you hear me now? Okay.
Yes, you're back. Thank you.
So we were always clear about our position. We're still clear about our position. And the appellant's claim that they had not withdrawn Dr. Stern is just false. I guess the final thing I would say is that we're looking at an appeal involving an order denying a motion for new trial. This was a highly experienced trial judge who watched this trial. He indulged the plaintiff's many, many arguments throughout trial, gave them a lot of leeway. They put on 12 witnesses to our 3, and the arguments raised on appeal are either waived or wrong, and there's been no showing of any abuse of discretion in either the evidentiary rulings or the ruling denying a new trial. And unless the court has any other specific questions, I would rest on our briefs.
Very good. Thank you. Mr. Gonzalez, you have your 3 minutes. Mr. Gonzalez, you're still on mute.
My apologies. Thank you, Your Honor. I'd like to address the point about the appearance of Dr. Stern and Mr. Fournier. I'm going back to the supplemental record, page 8387, and this was the page I referred to earlier, where Judge Muscarella said that, number 2, if he wants to keep Mr. Stern, that's fine. A few sentences down, Mr. Reed says, that's an excellent point. I'm not trying to stand on Mr. Yeard's opportunity to respond. So at that point, it was acknowledged, at least I thought, by counsel for the defense, that he was not going to oppose Dr. Stern coming on at that point. And this is what he says. This was the part that was quoted just a second ago. I think if I were to call Dr. Fournier or not, it would be a game day decision. Because if the case is going just fine and all they've got is the book, then I'm probably not bringing the guy. That's why there was a understanding or a mistake of fact on a part of the appellant's understanding that neither witness was going to be called, that Mr. Fournier was not going to appear, Dr. Stern was not going to appear. As we pointed out in our initial brief, when the witnesses were identified to the jury, neither Dr. Stern nor Mr. Fournier were included there. So that was how we were proceeding when this occurred. When they made their game day decision to bring in Mr. Fournier, it was at that point that we had the unfettered opportunity to have rebuttal and have Dr. Stern come in at that point to rebut that witness. I'm using a term rebut because that's what needed to be done when that happened. In the middle of the plaintiff's case, you had a defense expert come in with a defense theory, and it immediately needed to be rebutted with Dr. Stern at that point. We cited the Mendez case, which I think is instructive on all of this, and that is when you don't have an expert who has offered testimony, then you get to call an expert to rebut or counter what the new defense theory that is being presented. And all of that happened in the middle of the case in chief. And so it should have been allowed for the plaintiff to bring Dr. Stern at that point. With regard to Dr. Yaffe, we made the argument that his testimony was speculative and should not have been admissible. We also made the argument in our brief, and this was on page 35, Dr. Yaffe was neither a urologist nor shown to be a stroke expert, nor was there any evidence Dr. Yaffe had reviewed any of the objective data demonstrating his review of the anatomy of Mr. Frawley or showing that there had been a stroke. All of that is what should have prevented this testimony, and an internist should not have been allowed to comment on the evolution of a stroke or the presence of a stroke by simply reviewing a film. There was an insufficient predicate for that. You could try to challenge.
Mr. Gonzalez, that takes us to the end of the time. We appreciate both counsels, your arguments today. I hope you understand I gave you both extra time, but there does come an end. So we are at that point. So thank you both. We appreciate the briefs, appreciate the arguments. That concludes the oral argument docket. We are adjourned. Thank you very much.
Thank you, Your Honor.